Anecdotally, by which I mean a friend of a friend told me, it seems that some employers are providing employees with settlement agreements on the termination of their employment without giving them the opportunity to take legal advice. So the question is, are these agreements enforceable? I'm Ian Pearson, and I'm the author of the Advisor's Guide to Settlement Agreements. As a general rule, it's against public policy for one party to require another to contract out of the right to bring legal proceedings, and this is especially pertinent when it comes to a statutory right given to an employee to bring unfair dismissal proceedings. In addition, when it comes to the employment relationship, there's an inequality between the two parties. The employer has most of the cards in their hands and the employee very few. But it's the position in law when it comes to settlement agreements that the employee or worker must have received advice from a relevant independent advisor as to the terms and effect of the proposed agreement, and in particular its effect on his or her ability to pursue his or her rights before an employment tribunal. So this makes it abundantly clear that a settlement agreement that does not afford the employee the opportunity to take independent legal advice is going to be void. So why would an employer not allow an employee to take independent legal advice? Well, I suppose the first reason may well be just plain ignorance. Ignorance is never going to be a defence, but in these very unusual COVID-19 times, employers may just not be used to having to dismiss employees and as such may not know the rules. But I would have thought that this is going to be a relatively unusual circumstance. My guess is that many employers do have a grasp of the rules but would rather that their employees did not go and seek independent legal advice. This may be because the employer is giving no more than they are due to give under contract, that's the contract of employment, or statute, for example, a redundancy pay, in which case any lawyer or independent advisor worth his or her salt is going to advise the employee that there is little point in signing any agreement, as they will get those sums whether or not they sign the agreement or any agreement or not. In addition, if the employer is giving no more than they are contractually or statutorily bound to give, it would appear there's no additional consideration for the employee signing the settlement agreement or contract, and therefore without consideration it is doubtful that the contract will be binding in any way at all. Perhaps the amount being provided is so small and insignificant that the employer deems the cost of providing a settlement agreement, which is likely to take a solicitor a couple of hours to draft, and the fact that the employer will need to take legal advice, which again will need to be paid for by the employer, and this process is just not worth it. Therefore, they may very well provide a settlement agreement, albeit one that's not legally binding, to reinforce the full and final settlement element of the agreement, even though the employee will still retain the right to bring legal proceedings. In some circumstances, the employer may well just have either messed things up or be in blatant breach of contract or statute and does not want the employee to go to a solicitor or an independent legal advisor because they're bound to spot the error and then go back to the employer and ask for significantly more money in order to settle a potential claim. It's also likely that there will be some circumstances when the employer is pretty sure or almost certain that the employee won't issue legal proceedings, and therefore the purpose of the settlement agreement is more to remind that employee of their obligations perhaps in relation to a restricted covenant or confidentiality, or even a bad-mouthing clause. So, in conclusion, a settlement agreement within the meaning of the Employment Rights Act has to be presented to an independent advisor for it to be enforceable, and without that happening, the employee may take whatever money is an offer and, at some later date, issue proceedings against the employer. So this is Ian Pearson signing off. For more details on this subject, please get a copy of my book, The Advisor's Guide to Settlement Agreements, which is available in hard copy from settlementagreementguide.co.uk, or alternatively from Amazon Kindle. Until next time, thank you very much. Bye.